Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. Let's get to the docket. First, I'm sure something big went on in the Lori Vallow, Chad Daybell hearings today. We'll talk about that. The OnlyFans trial is set, and somehow I think it will, in fact, take place before the Vallow and Daybell trial. And then finally, our dumb criminal of the day. Let's talk about it. Good day, aficionados. This is Crime Talk. My name is Scott Reich. You know the drill. Subscribe if you haven't, like if you do. Leave me a comment. Hit that little bell so you get notifications of when we go live or put up new content. Hopefully you enjoyed the live last night. It was very popular. We had a lot of people on there, and we also put it up on the podcast as well. And reminds me, you can always listen to any of the videos here on your favorite podcasting apps anytime. Simply download it from your favorite podcasting app. All right, let's get to the docket today for August 31st. Can you believe it's already the end of August? That's right. Let's go ahead and open the record for August 31st, 2022. First, what happened at the hearing regarding Chad Daybell and Lori Vallow this morning? We don't know because the court kicked out spectators and obviously no live streaming. No order has been issued regarding whether Lori's charges get sent back to the grand jury for reconsideration because they were charged improperly. No, don't know anything about that either. Now, if you were live last night with us, Larry Woodcock, and you think, well, why does that name ring a bell? Well, I've met Mr. Woodcock at CrimeCon, and he's actually called in. He's a Patreon member, okay? And he sent a question in last night saying, Scott, is there a hearing Wednesday? Yes, sir, there was. Why is the victim's family member? Remember, the Woodcocks are the ones that inquired about the missing children, JJ and Lori, and they're not even being kept apprised of what is taking place. That's right, the lack of communication, the secrecy that the DA doesn't even bother informing the victim's grandparents. Like I said, the people that basically got this whole investigation going regarding the disappearance of JJ and Tylee. What is going on over there? I don't get it. So, since we don't have anything to talk about regarding what took place in the court today, because it's also secretive and it's so prejudicial that it'll result in an unfair trial, I said, hey, let's go ahead and talk about what the law is. So maybe it'll trickle its way over to Idaho, down there to old Rexburg, Madison, counties. Let's see what they can do. The Sixth Amendment to the United States Constitution provides, in part, that in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial. Now, like many constitutional rights, however, the right to a public trial is not absolute, and courtrooms may be closed to the public in some situations. Well, the case is called Waller v. Georgia. The Supreme Court set forth the test trial courts should apply to determine whether the courtroom closure is appropriate. Now remember, the Sixth Amendment's right to a public trial manifests the traditional Anglo-American distrust of secret trials. A violation of the right to a public trial is considered structural error and thus not subject to the harmless error review. So what does that mean? That means that the appellate courts, even if nobody raised it at the trial court level, the appellate courts could say, we're raising this issue on our own. It's structural error to the proceedings. Do it all over again. The right to a public trial extends to many aspects of the trial, from voir dire to sentencing. And moreover, the Waller case held that the right to a public trial applies to suppressions hearings as well. Like when you try to kick off the DA, got to be public. The right to a public trial also applies to the states through the 14th Amendment due process guarantee. Overall, the right to a public trial may yield to other rights or interests, but only in rare circumstances, and the balance of the interests must be struck with special care. Now, the Waller case is the leading Supreme Court case on the Sixth Amendment right to a public trial and courtroom closures. In Waller, the defendants were charged with violating Georgia's gambling laws. Much of the prosecution's case in chief revolved around wiretap evidence, and the defendants moved to suppress the evidence. Following the defendant's motion, the prosecution moved to close the suppression hearing to the public. The trial court granted the prosecution's motion, closing the suppression hearing to all persons other than witnesses, court personnel, the parties, and the lawyers. The trial court reasoned that if the hearing were open to the public, insofar as the wiretap evidence related to alleged offenders not then on trial, the evidence would be tainted and could not be used in future prosecutions. The Georgia Supreme Court reviewed the trial court's order and held that the closure comported with the Sixth Amendment. It was okay. The Supreme Court of the United States, however, reversed, holding that the trial court's order was improper because the trial court failed to give proper weight to the Sixth Amendment concerns. The court noted that a courtroom closure must meet a four-part test to properly comply with the Sixth Amendment. First, the party seeking to close the proceedings must advance an overriding interest that is likely to be prejudiced. The closure must be no broader than necessary to protect that interest, and the trial court must consider reasonable alternatives to closing the proceedings, and fourth, it must make findings adequate to support the closure. The Waller test is rather rigorous and straightforward. While no court has explicitly stated the test is in the nature of strict scrutiny, like other government actions reviewed under a strict scrutiny standard, the government must demonstrate a strong interest along with the solution applied that has been narrowly tailored to serve the interest. All right. So when the government passes a law basically saying we're going to go against a constitutional right, it's going to violate a constitutional right, guess what? Strict scrutiny. You got to be so narrowly tailored and so specific as to why it's being done. Court will justify it. Otherwise, it's bad. Do-over. Right? So the Waller test has been also applied not only to complete closures of trial proceedings, but also to partial closures of court proceedings. Back in 2010, the United States Supreme Court revisited the right to a public trial in a case called Presley v. Georgia. In Presley, the trial court closed the courtroom during jury selection, believing that there was not enough room in the courtroom to accommodate spectators. The Georgia Supreme Court held that the closure comported with the Sixth Amendment once again, noting in particular the trial court had no duty to investigate reasonable alternatives to closure. On appeal, however, guess what? The United States Supreme Court held that the closure was improper. The Supreme Court reiterated that the Waller test set forth the appropriate test for evaluating courtroom closures, and the court indicated that the overriding interest asserted must be specific and substantiated, and held that the required findings should also include specific findings of reasonable alternatives to closure, which the court must sua sponte make on their own. The court must consider. They don't have to wait for somebody else to come up with a plan. So a quick explanation of the law of closing courtrooms and not allowing the public in, it makes you wonder, why are the prosecutors, the defense, and the judge going along with this? The defense should be objecting to their client's right to a public trial being put in jeopardy because, well, the rest of the world can't watch and listen to what is taking place. The prosecution should be objecting and certainly not going along with it to preserve the record, and the judge should be saying, we are not going to do anything in private unless, well, we can comply with the Waller test. So, ladies and gentlemen, would have loved to have told you everything that went on in the public hearing today in the Lori Vallow Chad Daybell matters, but once again, they were closed. And now you've heard the law from the United States Supreme Court. So just keep going along with this, Judge Boyce. And guess what? On appellate review, it's structural error. Even if the defense agreed to it, they can raise it on appeal, and if it doesn't get any play, it's going to be ineffective assistance of counsel grounds, unless they can really come up with some reason as to what is so sensitive here that the world cannot handle. I'm not buying it. I think they're messing this case up, and who knows? Maybe we'll have Lori Vallow, Chad Daybell 2.0. Next, a trial date's been set for the OnlyFans, the Instagram model charged with second-degree murder in connection with the death of her boyfriend. Now, Courtney Clenny, known online by Courtney Taylor, will face a jury on December 19th at 9:30 a.m. there in Miami-Dade County. Now, she was just arrested and extradited back to Miami, and she's going to have a trial in December on a homicide case in 4 months. Wow. Think about it. The Lori Vallow Chad Daybell nonsense has been going on now for 3 years. Just a little perspective, ladies and gentlemen. Now, Miss Clenny's attorney reaffirmed the defendant's not guilty plea entered previously in writing on August 15th, and the defendant herself was not present during the 2-minute-long hearing. Now, records show that she has been held at the facility without bond since being extradited from Hawaii, and Clenny is alleged to have stabbed her boyfriend, Christian Toby Obumseli, back on April 3rd, fatally cutting his subclavicle artery, according to prosecutors, and those facts do not appear to be in dispute. The heart of the matter is whether Clenny acted in self-defense. Her attorney claims that she did. Prosecutors say that doesn't quite add up. Ms. Clenny's attorney said, "We are completely shocked at Courtney's arrest based upon the clear evidence of self-defense in this matter," per her attorney Frank Prieto. Now, Obumseli is alleged attacked her and choked her that evening, and Courtney had no choice but to meet force with force, Prieto says. And the charge is unfounded and baseless, and said that his client was clearly defending herself. Now, the Miami-Dade State Attorney, Catherine Fernandez Rundle, says that's not true and offered that their version of the events doesn't make sense when compared to the evidence. According to Rundle, an autopsy determined that a forceful downward thrust of a knife caused a wound about 3 inches or 8 centimeters deep in Obumseli's chest. The authorities allege that the force necessary to create a fatal wound of that depth likely came from an up-close and personal thrust of a blade. That's a problem, the prosecutor said, because Clenny allegedly told law enforcement officers that she threw the knife at Obumseli from a distance of about 10 feet away. The prosecutor then said the victim and the defendant, they shared an extremely tempestuous and combative relationship that was so rancorous that it attracted significant attention from their neighbors, security officials, and management at the apartment where the couple lived. Management of the facility even considered evicting the couple because of the many noise complaints. The prosecutors have stated that they also presented surveillance camera video from an elevator in the luxury apartment complex where the ill-fated couple lived and where the stabbing subsequently occurred in the couple's apartment. The video shows a melee between Clenny and Obumseli. Both the prosecutor and the attorney for Obumseli family say the video shows Clenny as the primary aggressor. Clenny's attorney, Mr. Prieto, has questioned whether the video is even going to be admissible in court. Probably not, unless, of course, she gets up and testifies. Miss Clenny gets up and testifies and said, "I'm a peaceful person. I would have never touched Mr. Obumseli." Probably at that point becomes admissible. Otherwise, probably 404B evidence and shouldn't be coming in. But we'll see how the court rules. Next on the docket, our dumb criminal of the day. And I got a chuckle out of this, as my daughter had done ballet for many, many years and danced from when she was a little baby all the way up through college. So it cracked me up when I saw Amy Harrington was arrested on April 27th on a DUI charge by a sheriff's office in Florida. She decided to show off her ballet moves during the recent traffic stop. Her prize, of course, being that she won a set of handcuffs. The body cam footage kind of recently gone viral, but it shows that the deputies responded to a rear-end crash and found Miss Harrington. Well, Miss Harrington had slurred speech and was unsteady on her feet. She refused to provide a breath test to the deputies, so the body cam video showed a deputy giving field sobriety tests. At that point, Miss Harrington told the deputy she thought his instructions were ridiculous. Harrington then decided to use the parking lot as a stage and showed off her various dance moves, including some ballet. The deputy asked her to walk along the yellow line, and Harrington exclaimed, "Oh my God, you sound like my effing ballet coach," according to the video. It was then at that point that she showed her dance moves. She continued to dance instead of following the deputy's instructions. As the police became less amused, the suspected drunk driver told them, "If you're going to arrest me, just do it." They obliged and put her in handcuffs and took away her dancing shoes. I remember watching some of those, what do they call them? I think sauté, pas de chat, jump the cat, move over the cat. Fancy French terms for ballet moves. I don't know. Cracks me up. Anyway, hey, that's all we have for you today. Thanks for watching. I want to appreciate everybody taking the time to watch Crime Talk. We'll see you next time.